Good afternoon, Mr. Shah. Good afternoon, Mr. Jawad.
Good afternoon, Dr. Rohit. How are you?
I'm fine. How are you?
Hi, Samir. Yeah, I'm good.
Good
Thank you.
afternoon. Good
Good afternoon,
afternoon,
Samir.
sir.
How are
After
you?
a long time.
Yes,
Yeah,
after
yeah.
a long time.
Hello,
Yeah,
Ashish.
I'm joining from my iPad. I'm in Ahmedabad, so the camera angle may look a little weird. I hope you don't mind.
No, it's
No,
all right.
doesn't matter, sir. Doesn't matter.
Um,
I'm in US right now.
he's
Oh, okay.
joining. He's joining from New York.
Oh, wow. What time is it, Samir, for you?
6:30 in the morning.
Oh, God. I would have been fast asleep by that time.
So what brings you to Ahmedabad, sir?
We have one mediation competition here.
Which
Yeah, and
university?
Gujarat National Law University.
Oh, GNLU. Okay, okay.
GNF, and they're doing it with
Hmm.
PACT, and they have
Hmm.
instituted an award in honor of Mr. Sriram Panchu.
Oh, very nice. Oh, very nice.
I am one of the awardees, so
Very nice. No, it's
So I
good to see now the ADR, you know, process is fast developing in our country,
yeah,
especially in the younger generation.
they are adapting to it like fish to water.
Yeah, I know.
It's the oldies like us who found it very difficult to think differently. I mean, Samir,
But
you're not an oldie. I'm sorry. Because Dr. Rohit
but
also doesn't look old. So.
no, no. But that is also, but there is also a problem, you know,
Mm.
when this kind of adaptation happens. That is also a risky factor.
Mm-hmm.
think
Okay.
Priya, you can start now.
Good evening, everyone. I welcome you all to the last session of the series of 5 introductory sessions on different facets of ADR organized by the Mediation Cell Faculty of Law. Today, the panel discussion is on the career prospects in ADR. Over the past sessions, we have explored a wide range of topics, particularly negotiation, mediation, and arbitration, and have heard from experts in these fields. In the absence of information, we tend to leap to the worst scenario. So we thought this session would help us all to achieve clarity on what is the reality versus what is the speculation or even exaggeration. This is an important topic that is affecting many in our legal field. So we are honored to create this panel to discuss the career prospects in ADR. Before we dive into a final discussion, I would like to express our deepest gratitude to our esteemed panelists, without whom this session would not have been possible. Your expertise, wisdom, and willingness to share your insights will enrich our discussion, leaving a lasting impact on our audience. We have amongst us Mr. Jawad and Mr. Samir Shah. Sir got trained as a mediator in 2006 or 7 under the Madras High Court Mediation Program. He has conducted mediations under the Court Annexed Program involving a range of disputes from civil, commercial to matrimonial and child custody. He has conducted innumerable mediation training programs under the Supreme Court of India's Mediation and Conciliation Project Committee, which trains lawyers and judges in mediation all over India. He has undergone training of trainers with ADR ODR International and has worked in AOI's university training programs as associate trainer. Sir has further conducted several TOT programs for the MCPC Supreme Court of India. In 2009, Sir gave up his litigation practice and decided to take up ADR full time. He is a partner and head of ADR services with KD Lex Chambers, who are the resident representative of AOI in India. And the list continues. The second panelist, Mr. Samir Shah, is a CLC alumnus, an advocate, international arbitrator, and a mediator with an active legal practice and experience of 29 years. Sir is the Director of Chartered Institute of Arbitrators, London, India branch. He's the founder and visionary of ADR branch, India. He is also a member of California Arbitration Indo-American Chambers of Commerce, Gujarat chapter, an international member of American Bar Association, advisory board member of Gujarat International Maritime Arbitration Center, a faculty trainer mediation IM campus, Germany, a member of National Committee for Legal Services Confederation of Indian Institutes, and the list continues. We welcome you, sir. With that in mind, it gives me great pleasure to introduce our esteemed moderator for today's session, Dr. Ashish Kumar. Sir is a senior assistant professor, Law Center 2, University of Delhi. He has been a driving force behind many successful discussions and events. Before we proceed further, we have amongst us Dr. Rohit Munka, Senior Assistant Professor and Co-Director, Mediation Cell, Faculty of Law. It gives me immense pleasure to invite Sir for delivering a welcome address.
Thanks, Priya. So it is on behalf of Mediation Cell, it is my honor and privilege to welcome both the guests, Mr. A.J. Jawad, Mr. Sameer Shah, for joining us and sharing. They are going to share their practical insight with the student. Of course, students are very keen about ADR, but you need to know why we are talking so much about ADR. What is something unique about ADR and why suddenly people have started talking about ADR? There have been many avenues coming up in the recent past. You must have heard about Arbitration Conciliation Act being amended thrice in last 7 to 8 years. Mediation Bill 2023 being passed by the Parliament. You have ODR. In fact, SEBI has allowed ODR recently, and ODR is also coming up, and Mr. Jawad is there. So there are many avenues, many diverse scope in the field of ADR. And one more thing I would like to state in my welcome, that of course the speakers are going to address, but apart from the career prospects, ADR, particularly mediation, negotiation itself is a life skill. So learning about ADR, particularly negotiation, mediation, is something will give you a lot of valuable insight, a lot of life lesson, how to deal with disputes in a day-to-day affairs, which every one of us we encounter in our day-to-day life. So I welcome both the panelists and of course our moderator, Dr. Ashish sir, who is part of the mediation cell. And the very objective of this cell was to, to bring experts like Mr. Shah, Mr. Jawad, and others to share their practical insight with the students on different aspects of ADR, particularly on mediation, negotiation, and arbitration. So I welcome both of you, sir, and looking forward to your. Yes.
Thank you, sir. I now request Ashish sir to come and take over.
Thank you, Priya, for being so gracious, introducing all the panelists and myself. So, since both the panelists have been profusely introduced by you, so I think we can now proceed with the panel discussion. So I understand that this session in its entirety is of 1.5 hour duration, if I am right. And both the panelists are invited to share their thoughts, as Dr. Rohit Munga sir also pointed out. So my job is to make sure that the conversation proceeds in the right direction. If it is a discussion on ADR, then of course the questions and the insights to be shared must be focused on the ADR and the job prospects, career prospects in this arena. So to begin with, I think being the moderator, I should say a few words about the career prospects, which the students must not miss. ADR, currently it is being offered as a compulsory paper in the Faculty of Law, University of Delhi. And since 2016, we have introduced, a lot of activities, a lot of exercises, simulation exercises inside the classroom. So the focus of the ADR as a course offered here is mostly on making sure that the students are exposed to the nuances in the practical sense of the various facets of ADR, including mediation as well as negotiation. So far as the arbitration component is concerned, we still rely on the theoretical methods, but insofar as the other two methods, negotiation in particular and mediation, we expose students to the various practical facets of these two processes and making sure that they understand uh, the underlying processes and the role of the mediator in particular, as well as the role of the parties and the role of the lawyer if the lawyer is invited to participate in the mediation process. So overall, having taught this subject for the past so many years, in particular the new syllabus which we have been teaching, we really look forward to the January session when this ADR is offered to the final year students. But as I have been telling my students, ADR is something which provides you the life skills. So even if it is offered in the final semester, it doesn't mean the first year or the first semester student should wait for semester 6 to be exposed to the ADR. So I tell all the participants here today to have pen and paper ready, as I am now also keeping pen and paper ready, and to note down the important points, and to participate in a very constructive fashion. If they have queries, they can raise these queries, they can note down the answers given by these two experts, well-known experts on ADR in India. So it is going to be quite an exciting session, and I hope the panelists will share their key insights, their key mind on the nuances, the practical values of these two processes of the ADR. So I first of all, the theme of the today's session, today's panel discussion is the career prospects in ADR. So I invite the first panelist, Mr. Samir Shah, who is a noted expert in this arena, to share initial few, at least he can consume 5 to 6 minutes, sharing his thoughts on the broadening horizons of this field. And this will be followed by opening remarks by the other panelists, respected Javed sir. So first of all, I invite Mr. Samir Shah to share his thoughts.
Thank you, Ashish sir, for this. As in my introduction, I am a CLC alumni myself, and
Okay,
it's
sir.
really very nostalgic today. It takes me back to 1991 when I started in the campus law center as a student. But what we have been taught, uh, you know, as a matter of our own culture,
Yes,
and
sir.
which I think is also should be a learning for the student as well. That if you want to grow and be successful, always respect your seniors. And
That's right.
therefore, I would invite Jawad sir first to speak up on this topic rather than myself, being a junior to him, to start this panel discussion.
Okay, no
Jawad
issue.
sir, over to you, please.
I think in one stroke, Samir very subtly reminded me how old I am. Thank you. Thank you, Ashish. Thank you, Dr. Rohit, for the welcome. Thank you, Priya, for the introductions. And students, good luck to you for the next 1.5 hours. Well, Samir has conceded the floor to me for whatever reasons. But here's my point of view, okay? Now let's look at the legal profession, where it is heading today, okay? Basically, what are the different divisions that we have? We have transaction law, we have litigation, we have corporate law. Now, if you look at all these, and we have, arbitration, of course. Mediation is yet to, reach that level that arbitration and litigation have reached. But what is the situation today? Let's look at it. Okay. We have about, if you look at it purely from the perspective of, dispute resolution, We have about 5 crore cases pending in all the courts in India. And according to the Niti Aayog, it is going to take us about 348 years to dispose of all these cases, provided no new cases come to the dockets of the courts. In this scenario, what is the situation? I'm talking only from, I'm not talking from the perspective of transaction law, I'm not talking from the perspective of any other, but purely from the perspective of dispute resolution. The paradigm that has set in, like when I entered my practice 35 years back, that was sometime in 1988, 87, 88, the only option for lawyers was to go to the court, because that was the only avenue for legal practice. Of course, you used to advise clients on, when they entered into contracts, they would come and consult you. Conveyancing was one field where you could, without going to court, you could work. But generally, court practice, litigation practice was the only avenue left. But today, the scenario has changed. Diverse verticals have come into the legal practice. There are firms that have different verticals today. And I think one of the biggest disruptions that is going to happen, or that is already happening, it's not going to happen, it's already happening, is technology. Now, how is technology going to matter to us in the different verticals that we are working in as legal professionals is something that we need to examine. Now, I just wanted to test ChatGPT, so I gave it a few facts about my wife and said, please compose a poem in praising my wife. And in a matter of seconds, I had this lovely poem which I sent to my wife. I was in Nagpur at the time, she was in Chennai. I sent it to my wife. She became very emotional reading it. She said, it's so beautiful. I said, don't thank me, thank ChatGPT. I shouldn't have said that, but I said it. So, if any, today, what is going to be the role of lawyers? First of all, we are advisors, right? We advise people on what to do if supposing a problem arises. And what happens if clients no longer need that advice? All they have to do is to just ask AI, this is my problem. What should I do about it? And perhaps AI will give the answer for that. So, as an advisor, what is going to be your role? I don't know. Okay, we may argue that, okay, the human element and all that, but that is something that we don't know how it's going to work out. And why should I pay a lawyer a huge sum of money for advice that AI would probably do in a matter of seconds, free of cost? I just have to pay for for downloading the app, or maybe I may have to pay a nominal subscription every month or every year. The second point would be where, transaction law, preparing contracts. Now, if I feed a few little bit of data into what I need, perhaps AI may churn out an agreement, because that AI drafted agreement might be more foolproof than perhaps what any lawyer would give. So, where does that put us in the future? What are the prospects that we have? The third point would be litigation itself. Are we going to have conventional courts with judges sitting over there delivering judgments? Or are we going to have machines sitting over there? You put the data, you say that these are my points and these are my opponent's points, and so what is your judgment in this? And who knows that one day AI may come up with a judgment. And we may have AI judges sitting, delivering judgments. I mean, these are all projections. I mean, something that we could not imagine before is happening today, and who better can understand that than the youth of today? Because we belong to a generation who Mark Krensky calls as digital immigrants. We are trying to learn the digital language, whereas you people are born into it, and you understand it much, much better than us. So, in that scenario, what is going to be the future of lawyers as such? Are we going to belong to the useless class that Yuval Noah Harari talks about? In his book, I think Homo Deus, he talks about that, where he says there's going to be like how we had the working class, like that we are going to be having a useless class because a whole lot of professions are going to be taken over by AI. So where does that put us? Where do we stand? And what is it that you're studying for the next, for 5 years in your law school? And how useful is it going to be when you come out unless you couple it with technology? So technology is going to be the biggest disruptor. Now here's where I had a different experience. I was thinking, what about mediation? What happens if AI takes over mediation? If you have an AI mediator. Now I read somewhere that IBM has developed the of course Watson is quite well known, the supercomputer developed by IBM, which can look at your face and predict what kind of emotions you're going through, what exactly you're feeling. So I was wondering, is it because
could you repeat this regarding
uh,
the emotion thing which you said?
no, IBM has developed a computer called Watson, Watson, WATSON,
Okay.
which can look at your face and tell you what exactly you're feeling. Are you feeling sad? Are you happy? So, we in mediation, we talk a lot about empathetic listening. We listen with empathy, blah, blah, blah. So Watson can do that. It can recognize the emotions that you're feeling. It can tell you that, look, Ashish, you're angry. Look, Samir, you're very happy today. So AI can do that. I mean, the computer can do that. But is it going to replace a mediator? So I was wondering whether I'm going to lose my job. And then what happened was I had a couple of experiences which showed me that Samir and I are not going to lose our jobs as mediators simply because there is a human element to conflict which only another human being can deal with. And I'll just give you these two examples and I'll stop there because I don't want to take too much of time on this. Just two examples. Now, what happened was recently I mediated a case between two companies. It was a construction contract, and a claim was made for 8.5 crores against the contractor makes a claim of 8.5 crores towards unpaid bills against the employer. Now, the employer says that look, they have they left the work incomplete, they abandoned the work. I had to keep another contractor and do the work, so I have made a lot of deductions permissible under the contract, and I owe them only 25 lakhs. Now, what happened was when the mediation started, they were at 8.5 crores on one side and 25 lakhs on the other side. Huge gap. Now, what happened miraculously, because I asked a few questions to the contractor, and the contractor said, sir, I understand that I'm not going to get 8.5 crores, but 1.5 crores is something that I deserve because that's my retention money that they're holding. They have to give me back that money. And plus, I want some 40 lakhs towards the amount, a kind of a notional interest or compensation, whatever, for holding my money for so long. They've been holding my money, so let them give me 1.4 crores or something, and we will settle it. Now, what happened was we started from this position of 25 lakhs and 1.4 crores. And the gap became narrower and narrower and narrower. And I kept on pushing them a little by little. I said, hey, look, the other company came up by 40 lakhs, then they went up to 50 lakhs, then they went to 55 lakhs, and this company came down to 75 lakhs. So there was this gap of 20 lakhs between them. And I said, look, we have made so much of progress. And you've done a beautiful job, such a good team effort between the two of you, and you have come so far. And the gap is very small now. What can we do about it? So now they have come down to, there was finally a gap of about 10 lakhs. And now they have bridged that gap and they have come to 65 lakhs as a ballpark figure. And both of them have said that we'll get back to our management and we'll get their confirmation and we will settle this. Now, my question is, could AI have done this job of moving them from those positions and brought them so much closer? I don't think so. Now, in another case, this is not a special technique that I'm talking about of mediation, but it is more about the human element that is involved in the conflict. And this was a case where there was a partition dispute, and between the eldest brother, who was about 10 years older to the other siblings, and therefore he was claiming a lion's share in the property and the assets of the father. Because he felt that he had helped the father in developing the business, therefore he deserved more. And he had helped the younger siblings to study. So he was working with the father, so he felt he deserved more. Now what happened was in this mediation, it was an in-person mediation, and the mother used to attend every session of that. And finally, we could not resolve it. both sides were very adamant in their respective stands. There was a lot of emotion, a lot of anger on both sides. Police complaints had been filed against each other, too much of bad blood. So I realized that there was nothing I could do in this. So I thought I'll close the matter. And I looked at the mother, and the mother used to come for every session, and she'd sit quietly. Now looking at her face, I realized the anguish that she was going through. I used to be nice to her. I used to offer her water, order for some tea or coffee for her. So this was different. So on the last day, when I finally said that there's nothing I can do about this, and I'm sorry I have to close this meeting, she looked at me and said, Beta, I don't know who you are, but for the past few days, you're one person who has shown me some consideration. You have looked at me and you have considered me as a human with some feelings. I don't know how I can thank you for this, what I can do for you. Now, something really touched me, and I said that we in South we call mother as Amma. I said, Amma, you don't have to do anything, just give me your blessings. And something, I'm not the feet touching type of person, but there was something so, there was so much of pathos that, I just bent down, I touched her feet, and I walked out of it after writing my failure report. 10 minutes later, I'm sitting outside the mediation center in the lobby and I'm talking to one of my colleagues. 10 minutes later, the brothers and sisters come to me and they say, Sir, we have decided to settle this. And I asked, what happened? And they said, we saw the empathy and the kindness you showed to your mother, the amount of affection that you showed to your mother. You're a stranger. And we realized that as children, what have we done? We have only caused her pain and anguish. So we decided to settle this. So such miracles, how is technology going to make such miracles happen? I'm wondering. So in one of the webinars where I was invited to speak about, how AI would take over a legal profession, I had a simple answer. I said, as long as I cannot take Alexa and Siri on a date, I'm okay with AI. Let AI do its job. But beyond that, I don't think AI is going to replace a human being. So therefore, I feel that, for the future, I think students should focus, how are they going to use AI to, because the person who will be really, handicapped would be the person who doesn't learn the technology. So along with their law, I think we need to learn technology also. And I think one of the fields where I see a lot of development happening is perhaps mediation. I will talk a little more about this later on, but I want to stop here because this is only an intro. I think I've already taken too much time. I'm sorry. Samir, it's all yours.
No, thank you, Jawad sir. I think what you said about technology and the disruption, I completely agree with that. I mean, for people like us, it's a very sometimes we are put in a dilemma, how to take it forward from here, because we have been coming from a very traditional practice areas. The coming generation, the way they are exposed to technology and all the facets just on tips of their fingers on a phone or a laptop, it's amazing. I mean, so yes, they do have this very open-ended field in front of them, and that many times is a very risky factor, because when you have so many options available in front of you, you tend to become more confused which one to take. So I think before we go further detail into that, my thought process or my advice or suggestion would be that, you see, we are talking here today about ADR, which means alternative dispute resolution. Now, therefore, it is not the traditional system of dispute resolution. That is why it is called alternative. And when we are talking of alternative, it's definitely alternative to the court system, litigation, what Jawad sir was mentioning. So over the period, it was felt that courts are so burdened with the cases, and because of the system, because of the process as such, it's taking too long for delivering justice to the litigants, and therefore, it was thought that there has to be a, a way out to not only facilitate the courts in justice delivery, but also to the litigants who are fighting before the court for such long years. And therefore, the ADR prospect initially, I would say, arbitration came into being. But to be honest, this ADR was nothing new to us. If you go back to history, and it is still happening in our country, what is known as the panchayati system. It's a fusion of mediation and arbitration and conciliation together. What happens in the panchayat? Uh, I'm sure you people would be aware about that. But so it is nothing new to us. What we are discussing today is a very structured and formal process of ADR, be it called arbitration or mediation or negotiation. However, all said and done, I think before you as students think of developing or looking to a career in ADR, my suggestion would be that first of all you should be very very thorough with your knowledge of law, overall law, different aspects of law, different laws, because in ADR, be it called mediation or arbitration, ultimately your knowledge about law would be tested anyhow. If, let's say, giving an example, generally arbitration in our country is used for settling commercial disputes. Yeah. Uh, so if you are not aware, if you don't know contract law, if you don't know Transfer of Property Act, if you don't know, civil procedure, because ultimately there are processes. We have a very, very beautiful Arbitration Conciliation Act, which is a procedural law as well. So if you are not aware of procedures and the law, the general law, you cannot do arbitration. And for that matter, to an extent, I would say you also cannot do mediation, because yes, mediation definitely involves more of a human touch, the human factor, as Jawad sir very, very correctly mentioned about. But it does also involve it, when you're doing a commercial dispute mediation, it does also involve some angle of law. So therefore, if you as counsel or sitting there in mediation or in arbitration, or you as a mediator or an arbitrator is not aware about this law, the subject matter, it's not going to help. I mean, it would be a disaster. So therefore, before I think you look at your career, your career into ADR, uh, please first of all, equip yourself with the best knowledge of all the laws which you would be taught during your 3 years of traditional law school, process in CLC, uh, and then you supplement, or you can decide which aspect of ADR you would be interested into. But even before going there, I would also suggest that apart from your theoretical knowledge in the law school, you should also have some minimum basic experience of litigation, court practice. Because mind you, in arbitration is almost in our country, which is, I would say, a little unfortunate that it's still uh, a process of a mini trial outside the court. Uh, but having said that, I would say that before you foray into arbitration and mediation, it's advisable, and I suggest that you at least have minimum 2 to 3 years of court practice to understand the process, and then you foray into ADR, because then you would be equipped with the procedure, of both the substantive law and the procedural law, which will be very helpful for you to be successful in ADR. I have seen, because I do coaching, I have been training, and I'm very focused on student development in our country since almost a decade now. That's why I've come up with this ADR bar, which is the first such concept in my knowledge, even anywhere in any other country. Uh, you can go to that website. It is adrbar.com and be part of it. It is based. It has a very robust, focus on student development, student membership, and it's free. So please join that. But as I was saying, that have this theoretical knowledge of law and the practical aspect of court practice, and then foray into ADR. I have seen, young students straight away going into arbitration because they are fancied with the whole process. They may have seen in their internships, attending such mediation or arbitration meetings and proceedings, and they just get fancied. Don't make that mistake. It will be a disaster to you. Yeah. So if you really want to be successful, you have to give time. There is no such concept of overnight success. Okay. Give time. Have this knowledge of law which you have been taught in law school. Have the practical aspect of the court practice, and then foray into ADR. I think that's what I would start with, sir.
So, staying with you, the very fact that the students must be exposed to the nuances of the litigation so as to be successful in the ADR profession. So, from the point of view of a student, like we also used to be a student, so we also had this lot of dilemma as to which area we should focus more. And these days, when I see law students are being encouraged to go for internship in the very first semester, and they are being given time for doing so. So, from that point perspective, what I really want from you to hear is that from a student's perspective, how much time they should give. Like, should they be allowed to go and to the courtrooms and be exposed to while they are simultaneously pursuing their LLB course? How to manage that time? I mean, how to be focused in the law school? What do
So
you say?
that's a very very pertinent question, sir, from a student angle, and I can understand as I was telling when I was student at CLC. I mean, we didn't have these kind of advising coming from experts. Uh, we just have to manage on our own. So yes, my advice to the student would be that if you really want to excel, as I was saying in ADR, or even in your career as a lawyer, you have to inculcate the habit of reading and research. That's very important. गाइड पढ़ के लॉ करना आसान है,
Exactly,
बट वो
sir.
करियर नहीं बनाता है. आई डोंट नो वेदर वो गाइड अभी मिलती है कि नहीं सीएलसी पे.
आपके जमाने में सर था वो जो यहाँ पे
या
दुखिया मिलते हैं?
हाँ हाँ, वो पीछे कैंटीन
हाँ,
वालों
वो
चाय वाले पे
जैन
मिलते
जैन
थे. आई
जैन
नो.
साहब.
या सो डोंट मेक दैट मिस्टेक. The reason I'm saying the reason I'm saying this is what I have seen, that law in our country is a secondary prospect, career prospect for students. In spite of the NLUs, in spite of these intensive law programs coming across, if you take out the average of the students who are there in law school and those who actually come into practice, it's minimal as such. It's still treated as a secondary career prospect, which is very unfortunate. So my advice to the student would be that if you really want to excel in this field, be prepared and inculcate this habit of reading every day and researching. That's one. Second, There is no harm, and I think I would advise that you start attending the course even during your LB course to understand how it processes out. And the best way which I learned, which I'm sure the current generation would never like to do that, but that's the best way of learning is, when I joined, I started uh, my career as a lawyer. Just passing after from CLC in 1994, I was asked to go along with the court clerk on the very first day by my senior, and I was feeling so insulted. I was saying I'm a lawyer, and he's asking me to go with the court clerk. He said, "Yeah, you have to go with the court clerk. Go along with him. Just be with him for the day." And this happened for 1 month. But now I realized that today I know the whole process of how a case is filed and how it comes before the court. And secondly, because of the reality which is corruption in our country, I now know how the file moves from the registrar's table to the court. Okay. I now know that if today my clerk is saying that it would cost this much amount of money, I know whether he's saying right or wrong because I have gone through that personally. However, today's generation, I mean, with all due respect, they would not like to go into this because they have that if we are lawyer, why should I be going and doing a clerk job? But that's the basis. You must know this aspect of the whole process. Then only you would be able to advise your client within what time your case would come up and within what time it will go through the process. Then only you will be able to advise your client about the whole process because client will ask you. And if you don't know, what answer you will give? So do this. Go with the understand the process of filing, which I am sure is not being taught to you in the law school. This is the practical aspect of you being a lawyer. Even in ADR for that matter, there is a process, especially in arbitration, how the statement of claim is to the notice of arbitration has to be invoked, how the statement of claim to be filed, how the statement of defense would come, what would be the way the pleadings would be followed up, witness examination, expert exam. So this whole sort of process, and you have to learn this. And how do you learn that? It's only through your internships, or when you are going to the court, or when you are attending some particular ADR. Though ADR is confidential, of course, you need to take permission from the mediator or arbitrator and the parties involved, but you can still do that. So keep on, continue doing that. Third, I would say is mooting. It's very, very important. It hones your skills into the practical aspect of area and initially, of course, the court practice. So, therefore, and I have seen that not all the students get involved in the moots. There are few selected who would go into moots, but I think this should at least mooting should become, a continuous process throughout at least your law school curriculum to learn the nuances of court practice. So these are the, I think, three important sessions I would start with for the student to, even think of going into ADR.
Wonderful, sir. So we are witnessing, two streams of thought here as regards this theme for panel discussion. And as Samir sir has pointed out, that the importance of reading is not going to be reduced, and as well as the researching skills. So those are the remarkable insights. We will come back to those insights later on. Now, I would like to ask Javed sir, staying with what he was espousing here, the role of technology in the arena of ADR has become you know, so all pervasive that we cannot deny its importance. So, at this particular point of time, what do you think, sir, in the law school, how we are going to, should we revise our syllabus and provide components on AI and ADR, for example? Because everybody is talking about the fact that the legal profession is going to come under immense pressure because of this rapid AI technologies. So how we are going to balance the AI component, the machine learning? Because as Samir sir has also pointed out, the law schools in India, I mean, most of the people come from a very moderate background, and in the uh, we all know that the students who were not able to clear, that I'm not generalizing, but the students who were not able to clear medical or engineering, usually they do join this law school. So most of the students have got this, non-technological background. So Javed sir, please share your thoughts on this particular point as to how we are going to balance AI component in the law curriculum.
Yeah, thank you, Ashish. And see, I see a lot of sense in what Samir is saying because the current legal system, as we have it today, is operating on that paradigm. Now, what is that paradigm? And what is the curriculum of the law schools designed today to teach to students? Now, the whole thing operates on a fault finding paradigm. Okay? So, what do you teach? What are the laws telling you? What are the procedural laws telling you? Basically, how you file a pleading, how you frame a pleading, how you file it in the court, how the court is going to hear this. All these are the procedural laws. And then we have the substantive laws which describe the rights and wrongs, basically. Okay, now the effort or the curriculum as it is, as it stands today, if I'm correct me if I'm wrong because you are better equipped to comment on that or you have better knowledge of that, is basically on a fault finding paradigm where we teach students how to apply the law to either defend something that your client has done or to attack somebody who has done something to your client. Now that's how the law legal education is structured and that's how the law practice is structured. Now, what is important today, I feel, because in the in the current scenario where the courts are overburdened, arbitration is proving to be an equally prolonged process, which is not really rendering the kind of expeditious disposal that we expected it to do. In the face of all this, what should the law students become? What should the future lawyers be equipped with? And my belief is that they should be taught a more problem solving approach. So, back in our days, what we used to do, the moment the client would come to us with a problem, the first thing we would do is draft a legal notice, shoot off. Making all kinds of insinuations and telling that, oh, you did this and you did that and this is why you are wrong and therefore my client is entitled to blah blah blah. So this is how we used to do it. And then the reply would come and then we would go to the court. But today, do we really have the time and the patience to do that? And why are our courts overburdened? Because arbitration ultimately goes back to the court. So there's not a single award, even though the grounds for challenging the award are being narrowed and narrowed further. But every award invariably goes back to the court on some flimsy ground or the other. And it takes eternity for it to get disposed of over there. So how are we going to deal with that? My feeling is I think the whole approach should be a problem solving approach. Okay. Now all these, see the British left behind a legacy of complicated ways of doing things. Like for example, if an ordinary man gives another ordinary man an orange, he will say, "Here, take this orange." Now, if a lawyer gives that orange, the lawyer will say, "I so and so, son of so and so, residing at so and so, belonging to so and so relative, do hereby transfer, convey, and give unto you all the right title and interest that I have in the orange." So, do we really need that kind of complication? Do we really need the kind of procedural complications that we have today? Now, one of the very encouraging things that we see today, for example, our Chief Justice of India, the current Chief Justice of India, is totally sold on technology, and he wants to expedite the processes. Okay, he's encouraging people. Once I was in Justice Nariman's court, and there were some papers that were required. And instead of asking them from the registry, he just told the council, he said, just go take a Xerox copy and bring it, that should suffice. Now, what we are doing today is, I'm talking about the use of technology. I'm talking about simplifying the procedures. Now, do we really need to go into those kind of elaborate procedures? Now, if you want to send a legal notice, I just, prepare it on my iPad and I affix my signature and I shoot out an email. Now, I do a lot of arbitrations too, as an arbitrator. Now, my entire sessions take place online. The entire correspondence is online, except for the first notice that I send when I don't have the email ID for the party. That is the only physical correspondence that I do. I have to sign and post the notice. But once the parties come, it's entirely online. So that is where I feel that we need to think about simplifying these processes, making them more understandable to people. Take away the kind of the kind of gravitas and pomposity that we are attaching to the whole thing. Now, for example, when you go and sit in the court, you take one section of law and you dissect it. You try to interpret and bring in different interpretations of it. Now, all your client wants is this problem to be solved. The client is not interested in the nuances of the law. The client is not interested in how flowery arguments are. Perhaps a few clients may get carried away with it, but basically they want the problem to be solved. Now, here is where I see an integration of different dispute resolution processes. First, negotiation doesn't work. Mediation doesn't work. Arbitration, of course, whatever the outcome, either you accept it or you don't. But my feeling is the adversarial dispute resolution processes should be the last resort. And that is why your curriculums have to be designed on a more problem-solving paradigm rather than a fault finding. So what we are teaching basically today, we are teaching students a lot about laws. What are the laws? What are the judgments? What the laws say about so many things? What are the procedural laws? We are teaching all this. But we are not teaching some essential realities of life. Why do people get into conflict? How does conflict arise? What are the emotions at play? What kind of skills are required to deal with those emotions? So, isn't it necessary for a lawyer to look at a dispute in a holistic way rather than just looking at it from a legalist? See, every conflict is a human conflict. Basically, it has a human being behind it. And those human beings are victims, they suffer from their own perception, they suffer from their own cognitive biases. They have their own emotional issues, the way they look at things. Even commercial matters, even purely commercial matters have a human element to it. Because it depends on, when I do mediation, I realize how much emotions play a significant role. In a purely contractual dispute, in a joint venture dispute, there might be something that might have happened between two CEOs on a personal level, and that has led to a dispute. Now, are we teaching our law students the human element of what they are going to be doing? Basically, solving problems, solving conflicts. So I feel that that is where I think the legal education needs to be relooked. So instead of just following that fault-finding paradigm, are we going to look at it from a more human element point of view that, okay, basically these are people involved and these people have their own way of looking at things. Now, how do we solve the problem for them so that they can move on with their life? Now, imagine for these 5 crore cases, let's say that 50% or 40% of those cases are interpersonal conflicts, right? Where the law doesn't have to be playing a role. See, we need to move people away from the tyranny of the laws. I call it the tyranny of the laws. We are victims of the tyranny of the laws, the procedural laws, the substantive laws. Why can't we just move away from that and take a more, a humanistic approach to it and look at it from a human perspective and see what is necessary for the people to do? If that doesn't work, the laws are always there, the courts are always there. We can go back to it. But that should be a last resort. And that is where I think lawyers need to play a very significant role in how they're going to be dealing with conflict. And how are they going to use the technology also to enable the problem solving, to change this paradigm into a problem solving paradigm. So are we going to be problem solvers or are we going to be problem inflators? So many years back, I had this case where this lady came to me wanting a divorce. And she gave me a set of, she told me her story. I made my notes and I told her come back after 2 days and I have the petition ready. She comes back after 2 days and starts crying. I said, what happened? She said, after reading the petition, I came to know how much I suffered. Right? So I mean, it sounds like a joke, but the problem is what I did was she gave me certain facts and I had to twist them, distort them, stretch them a bit to make it come under certain grounds that are stipulated in the law for divorce. Now, why does she have to do that? Why can't we have a simple thing saying if two people can't live together, they can simply part ways and let somebody help them to talk to each other and resolve the problems? Why can't the law be simplified? Now, why are we are suffering under the burden of these laws. So I think it's high time we start rethinking. What I'm saying, I don't know whether the students will be able to understand this because they may not have that experience or the exposure, but what I'm trying to tell you here is, let us move away from this paradigm and let's work more on taking a more, people-oriented view of problem solving, conflict resolution. So that is where I think the law schools can play a very significant role if you can include in your curriculum subjects like emotional intelligence, people skills, how to handle people. How many of us know how to handle people? That's why we believe that mediation is a life skill, as Dr. Mohit pointed out. It's a life skill. We need to learn these life skills, and that should be part of the curriculum of a law school. Because lawyers are going to be becoming judges in the future. They are going to be arbitrators. They are going to be mediators. So, what are they being taught to do? So that is where I feel that law schools should change the curriculum, take a relook at it, and include these skills as an integral part of legal education, not just teaching them the laws, not just making them go sit in the courts and observe the flamboyance, the pomposity of the lawyers. Today I went to the aquarium here in the Gujarat Science City and saw the penguins. It reminded so much of what I used to be as a lawyer. That's it. I hope that answers.
Yes, sir. Fine, sir. Now, staying with the theme of today's panel discussion, I think we must know what is the reality of ADR. What are the job prospects in concrete terms? Like, we keep on hearing so many positions open. For example, in the Singapore Center for Mediation, even I was interested some 5-6 years ago to be a case manager in the field of ADR. So I was not knowing what the case manager does in the mediation center. Similarly, in the arbitration center also we have. So like overall, in order to push students, to encourage students to think more about ADR, obviously sir has pointed out, Samir sir, that law is extremely important, and Javed sir has also highlighted till now that the role of problem solving skills is of immense utility for the students. So therefore, in view of all this, what do you think, sir, Samir sir, what are the career prospects in the field of ADR? Like we say that after you pass out, you become a lawyer, or you join an NGO as a legal advisor.
Very rightly asked, sir. I think yes, from a student perspective, they would be, uh, confused. They would also like to know what is next apart from being a lawyer. What's the other perspective? I mean, whether there is a scope in ADR. My answer to that is yes. There is definitely a huge scope for developing a career in ADR uh, in our country and even internationally as well. But the thing is, how do you build it up? So I would give certain suggestions to the students how they should be approaching or building a career in ADR. As I said, you need to understand the basics first. Like in the law school or even in your career as a lawyer, if you don't know CPC and CRPC, which are the procedural law, you're not going to, I mean, it's not going to help you in the court practice because you don't know the process. So I think even in ADR for that matter, you need to understand the basics. Now, so far as arbitration is concerned, apart from your law school teaching, there are certain very pertinent professional institutions who provides trainings to become to hone your skills into arbitration. Uh, so one aspect is to join these trainings. You can join even during your law school as a student as well, and hone your skills into different aspects of arbitration. One such institution is what I'm being part of in India is known as the Chartered Institute of Arbitrators, and as one of the directors of the India branch. So this institution is, I think, one of the very prominent international institution which
I think
trains
so.
you
It is
into.
one of the oldest, right? One of the
Yeah.
oldest. It is one of the oldest
Yes.
arbitration institution.
Yes. Yes. Globe. I mean, based out of UK, but having branches across, I think, 130 plus countries. So, it gives all these trainings right from the student level till the topmost being the chartered arbitrators. Yeah, which which helps you in honing your skills into arbitration. Though this is these trainings are more focused on your role as an arbitrator, but there are institutions who also gives you the overall trainings more from the council perspective. So one thing is that join these trainings, and once you do this, uh, what next? The next I would say is to keep uh, networking. That's very important. You see, today even your law school is does not guarantee you employment. Nobody guarantees employment. Even these training institutions also will not guarantee you employment. What they help you is they gives you that platform which you can use to network and get employment. So networking is very very important. Today's and that's where technology come into play. Social media, LinkedIn for that matter. I think that's the one of the best medium to network, and I have got so many references from LinkedIn. But I was just speaking a few weeks back on an interview which was taken of me by the association arbitration association in California, and what I told them there is that whatever you do on social media, be honest. Don't boast all those stuff which we are looking for. Be honest. But yes, so networking is very important. Third, if you really want to understand arbitration, there is a very interesting course which is being done by Singapore Arbitration International Arbitration Center, the Hong Kong International Arbitration Center, and of course CIR. and that is called the Tribunal Secretary course. Now, what is this? The term, if you look at secretary, when I was discussing this with students and new the trainees, they would say, "Are you talking of how we don't want to be a secretary?" I mean, they look upon this as a very clerk kind of a
Very
job,
good.
but it's not like that. Understand, in international arbitration, especially, the tribunal secretary plays a very important role. That person is actually a bridge, a medium between the arbitrator and the parties in the council. So everything, the whole process of arbitration runs through the tribunal secretary.
Is it the same
And
person? Is it the same position, just as the case manager? Like,
no,
dispute?
no,
Okay.
it's different. I mean, I'll tell you a difference.
Okay.
It's similar but not the same. Now, so far as tribunal secretary is the person who actually sits. He or she is the only outside third party who is permitted to sit in the arbitration proceedings. So, what does a tribunal secretary do? All the communications, filings, processes, whatever is happening in an arbitration is submitted to the secretary. So he or she organizes the whole process, communicating, sending notices, and everything is through this tribunal secretary. Whatever is being said and done in this, and it's a very important role without which no good arbitration can be conducted. So therefore, I would suggest that take this course as the first step. I would say an initial step of yours into arbitration. Uh, Furthermore, you can choose between being a counsel in the arbitration or an arbitrator. But so far as I would suggest that if you want to be an arbitrator, I think you need that experience. So just don't jump into that. Don't, as I said, give time. You need to give time to hone your skills. Don't jump straight away. I have seen students coming out of law school and simply straight away going to Supreme Court as a lawyer without even knowing the process of whole trial. How they going to argue before the Supreme Court whether the whole trial was right or wrong? So don't make that mistake. Go step by step, whether it's your career or in your life. Go step by step. So don't jump. Try to first become a counsel, understand the process, and then through that experience, try to become. Then you should become the arbitrator. So these institutions will give you, and CIF actually gives you this training, where even in just 2 years' time you can become an arbitrator if you pass those training and the assessments. But I would suggest don't make that mistake. Have at least minimum 5 years experience as a counsel in different aspect of lawyer's career, and then move on to be an arbitrator. So having said that, this apart from that, other prospect, other career options would be you can join a law firm, be part of their vertical of the dispute resolution. Most of the good law firms across in our country and across in international as well have a very robust, distinct dispute resolution vertical. So you can join these law firms. You can continue with your academics, do LLM, be part of academics teaching. That's another prospect. I mean, I have seen people going into academics, and there's nothing wrong. If you are passionate about it, you can go become a teacher, a professor. You can also go into, of course, being a judge. Uh, you know, uh, you can give judicial services exam and become a judge. So prospects are immense. It's how, or now in nowadays and future, you can have a legal tech company of your own, or join such legal tech companies, which are, I mean, there's so many such across. So there are prospects, immense prospects. The field is open. It's only how you, approach it, I would say.
Fantastic, sir.
Ashish, can I just add something to what Samir said, if you don't
Yeah,
mind?
yeah, yeah. Yeah, go ahead, sir.
Yeah, just to add to what Samir said, I think basically tomorrow's lawyers will be, need to have a different set of comprehensive skills. So, what I would suggest is that apart from whatever Samir has said, I think students should also equip themselves with negotiation skills, undergo some good negotiation courses, learn how to negotiate, how to use the concept of principled negotiation, because a lot of the work that you will be doing for your clients would involve negotiating, because getting into deals, helping your clients to close deals with others. So on all these aspects, I think negotiation will be something very important for them. The second would be mediation skills. In mediation skills, it is not just dispute resolution. Mediation, you can be a mediator even to close a deal. Because what happens, you have two sides who are negotiating with each other. If supposing two companies want to enter into a contract or into a joint venture, they will be negotiating, they will have their own lawyers, who will be looking at it only from each client's perspective. So having a mediator there is known as a deal mediation. It's called as deal mediation. So having a mediator there who can, facilitate that negotiation and help them to look at each other's perspective and reach a deal that would be fair to both sides. That would be dispute preemption. So the future is going to be on the preemption, not dealing with the problem once it arises. It will be preempting a problem from arising. So there's great scope for that. Another scope is mediation advocacy. Because when you are advocating for a client in a mediation, you need a completely different set of skills than what you need if you're in an arbitration or if you're in a litigation. Because those skills are more collaborative skills, where you need to have those again, negotiation skills, how to understand the other person's concerns and needs, how to deal with that, and how to promote your client's interests, how to advance your client's interests, how to move your client from the position to the interest. So that is a separate. So mediation advocacy would be something. And apart from that, of course, the arbitration training that Samir has already mentioned, and how to use the digital platforms in all these aspects. So how do you use technology for helping you to facilitate all these processes for your clients? I think that would be a very essential thing. Now, for example, how do you compose an email? Because what you say in an email can be interpreted in any way. So how do you put your point across through an email? How do you communicate over an email? Now, these are all things, because today, see, the legal paradigm is changing. Now, I read of a judgment of some foreign court where an emoji, a thumbs up emoji, was sent in response to a proposal, and the court said that's a concluded contract. So, these are the challenges that you will be facing in the future, right? So, I think you should learn all those skills that you need. How do you do all this? How do you communicate over a simple WhatsApp message? Because that can be evidence in the future. What are you going to say? What kind of stand are you going to take in your email on behalf of your client? So across the board, I think all these things. And that is where what we decided was, my organization, ADR International, which is based in UK, we are offering a DDRS course, Digital Dispute Resolution Specialist, where we give a comprehensive training in all these different verticals. I would not call them verticals. I would rather say that all this is connected with ultimately what a lawyer is going to be doing, what the future lawyer would need. So arbitration, mediation, negotiation, and digital dispute resolution. So all these skills will be required, and that is where I think this kind of training will really be helpful for the students and equip them in a much better way to face the future.
Yeah, fantastic, sir. So, staying with the idea, uh, we have also heard of this mediation being used in the arbitration forum, or in short term, we call it hybrid method, ARB-MED. and similarly in mediation, med arbing is being encouraged. So, Javed sir, starting with you on this particular sub thing, uh, have you come across? Could you please share how this particular subsystem operates while you deal with the mediation cases? So, what does it mean? Like many students have also asked this question often. Uh, what is med-arb or what is arb-med? So, how do they play out?
Okay, now let me tell you this, Ashish. From my perspective, I think that's going to be the future. Med-arb perhaps is going to be the future of dispute resolution, because see, we already saw this in the Arbitration and Conciliation Act.
Yeah.
Because Part 3 of the Arbitration Conciliation Act talks about the process of conciliation, which is identical to mediation. And the new Mediation Act actually does away with this whole difference between conciliation and mediation. So it calls it only as mediation. So basically a collaborative dispute resolution process. Conciliation also is a collaborative dispute resolution process. So
I think
an arbitrator,
Section 30 of the
yes,
ANC also mandates.
yes. Section 30, I'm talking about Section 30.
Yes.
Because it allows the arbitrator the right to refer parties to mediation or conciliation. So basically, what do we mean by MEDAB or RMED is this, that I'll just distinguish between these two very, very briefly as far as I can. Okay, yes. MEDAB would be the best way, because if every contract, I feel, should have a MEDAB clause. Because here's the challenge with mediation, though mediation is a very nuanced, very scientific process. Now, because the decision-making power vests with the disputants, not with the mediator. So, mediator cannot decide the outcome of a mediation. It is the parties who have to agree to resolve it in a particular way which is suitable for them. Now, sometimes it so happens that parties are not able to reach an agreement, and that is something that may require a binding decision from an adjudicatory authority, which can be the arbitrator. So what every contract should have is a mediation clause which says that if any dispute arises, parties can first go for mediation. If mediation fails, then you go for arbitration. Now, where this argument came into being was because we have the New York Convention, and mostly in cross-border disputes, unless and until the award arises from an arbitration, it cannot be enforced in another country, which is signatory to the New York Convention. Now, this was the biggest drawback with the New York Convention. It has to arise from an arbitration. So what used to happen was, people used to invoke the arbitration clause, then go for mediation. So that is what the ARB-MED concept is. So they start with the arbitration, they go into mediation. If they get the dispute resolved, then the arbitrator passes an award in terms of the agreement that is reached between the parties, and that becomes executable under the New York Convention in any of the signatory countries. So this is the only difference between MEDAB and ARB-MED. But now, because of the Singapore Convention, that problem is solved now, because a mediated settlement agreement is enforceable in a signatory country, a country which has ratified the Singapore Convention. So therefore, this differentiation, if we can understand this, the ideal situation would be start with mediation, try to resolve it through mediation. If it doesn't get resolved, then go for arbitration. Because arbitration, there is a certainty that it will lead to an award, because it's a decision taken by a third party, the adjudicating authority. That is the arbitrator. In a mediation, the mediator does not have the power to decide the dispute. Mediator only facilitates the negotiation to enable parties to reach a resolution that is acceptable to both. So this is the difference. And my feeling is the future is MEDAB. Because that makes a lot of sense, because you first go for mediation, try to find a solution. Now I have had cases where, in fact I'm mediating a case right now, in which the arbitral tribunal has already been constituted, has entered upon the reference. At which point of time the parties felt that, okay, let's try mediation, and they have come forward. So we are in the process of mediation, doing the mediation now. So if the mediation succeeds, they have two options. Either they go back to the tribunal and say that, look, we have reached an agreement in the mediation, please pass an award on these terms, or I pass, if the Mediation Act comes into force by the time this mediation concludes, perhaps I may be able to, record the settlement agreement, which will have the effect of a decree under the new act. Otherwise, I'll have to treat it as a conciliation and pass a conciliation act. But the better option for them, I would be advising them, if the act doesn't come into force by the time this mediation gets over, I would be advising them to go back to the arbitral tribunal, record the settlement as an arbitral.
So, do you also suggest, sir? Do you also, being mediator in a particular mediation, do you also suggest the parties when they have stuck deadlock has come and parties are not moving forward and you almost on the brink of termination. So, at that particular point of time, do you also suggest the parties to explore arbitration so as to to keep pushing the parties to resolve the issue using ADR method instead of going to the court?
Yes. See, one of the preconditions for invoking arbitration is to have a written agreement to arbitrate.
Okay.
Section 7 of the Arbitration Act requires that. So, if supposing, let's say, the parties choose to go for mediation and there's no arbitration agreement between them, so it is just a decision taken by the parties to mediate. Now, there is a possibility that the outcome of the mediation might be the parties agree that, okay, we are not able to reach an agreement here, so let us agree in writing that we will go for arbitration. So, at that point of time, if they record an agreement in writing saying that we will go for arbitration, they can go for arbitration. I hope that point is clear.
Yes, sir. So staying with the same sub theme, Samir sir, could you also share your thoughts on the idea of hybrid methods being often used? So you must have, sir. We know that you must have come across with any such instance. Could you share?
I completely echo what Jawad sir said about ARMED. I mean, sorry, MEDA. Uh, and personally, I also follow and try to, use the powers given under Section 30 when I'm sitting as an arbitrator, or even otherwise. Even if the parties are coming to me and seeking my advice as a lawyer, my approach would be to try to help them resolve the dispute. And that's what Jawad sir was also saying. I think we need to have the total change of mindset towards how you're viewing a dispute as a lawyer. And then only, these backlogs of cases, and I think then only actual justice would prevail in the system for the litigants. So you have to have a very different approach, especially when you are focusing on a career in ADR. The reason being, ultimately, you have to appreciate why the parties are coming to you as a lawyer. They are coming with an expectation that you would help them resolve the dispute. You will help them getting the result. Now, if you are just going round and round in circle, prolonging the whole process as we are seeing what is happening in court, that's not appreciable. I mean, the party would not approach you next time because, and so therefore, you have to have that mindset. Unfortunately, because of our traditional teaching, even now, we have the impression that as a lawyer, our job, our responsibility is just to win or just to represent the client in the court and win the case. That is what is inculcated in the mindset, even now. We need to go much beyond. We have to come out of this. I think, as a lawyer, we have a very big responsibility, a very important, role in the society as such. As I said, people come to us with an expectation. They see us as somebody who would help them to come out of their dispute, come out of their issues. So we carry a very big role. And if we are not fair to the parties, I'm not saying only to your client, you have to look from the other side as well. And that's what Jawad sir was saying. Why this dispute has happened? If you go into why, and that's where I think in your law school, one of the very important subject which you should be focusing on is jurisprudence, which will help you understand the why of a dispute. So, in nutshell, what jurisprudence would teach you is those questions: how, when, what, where, and why. So, please be serious about learning jurisprudence, and then try to inculcate that approach to all these disputes. I think you will really it will help you change your approach toward disputes in a much broader way. So therefore, as a lawyer, it's not that you have, of course, your prime responsibility is to protect the interest of the client, but not at the cost of the other parties. If you know that the other party is also right and your client is wrong, be bold enough to explain this to your client and say to your client that if he's wrong, he or she is wrong, that you are wrong. But then also help them understand how to overcome that in a best possible way, in a fair manner. That is what I think we are still lacking in our country as the understanding of your role as a lawyer, and that is very important. That needs to be changed. In coming back to, yes, this is going to be, and this should be the approach, I think, of you advising your client. In fact, this goes much beyond your advising. I think it starts with the drafting part of the contract. When you are asked to draft a contract, I think dispute resolution clause is one of the very important clause of any commercial contract, for that matter. And unfortunately, even now it is being neglected. Let me tell you this. It used to be called a midnight clause. This is a term which we use for dispute resolution clause, especially into cross-border international contracts. Why midnight clause? Because this clause was never given any importance. What parties were used to negotiate more on the commercial aspect of the whole contract, and then in the midnight, and let's say if there are two parties from different jurisdictions, one from, let's say, in India, another from US, and then, in midnight, one of the counsel would realize that, oh, we have not thought of, what will we do if there is a dispute. So they will just, without negotiating, they just write two lines that in case of a dispute within the parties, it will be referred to arbitration. That's it. Without realizing the consequences. Now, this could, in fact, I would say this could lead to much more dispute. Yeah. So understand the importance of dispute resolution clause or the agreement, and because it is actually the basis from where the whole process would start. So you have to understand how to draft a valid and effective dispute resolution clause. So all this, how you want to learn? This you want to learn only through the basics. These are the basics which I was telling you about. And therefore, when you're doing this hybrid mode of dispute resolution, see, the ultimate aim of ADR, what is the ultimate aim of ADR? Is to help parties finally resolve the dispute. Either ways. Yeah, that's the aim. And how you want to do that is by using these two very effective methods of dispute resolution together as a combination to achieve this final aim. That's why we say that MEDA, for that matter, is the best approach for dispute resolution. And I have been using it myself when I sit as an arbitrator. I have been always, in those initial meetups, I would definitely try to understand the reason behind the conflict between the parties. And if there is a scope of settlement, I was always, advise the parties to settle it out rather than going into the whole process. But these kind of approaches, very few, is doing right now in our country. But I think that is the need of the hour. That at least this young generation of students who would be coming into the practice area in 3 or 4 or 5 years' time, they should have this kind of a mindset. That's what I would say.
Okay. Yeah, fantastic, sir. So you also spoke about the opportunities available at the arbitration center, ADR center.
Yeah.
So we also keep on hearing about the support system which is available in the ADR center. So apart, like the secretary, tribunal secretary, you mentioned one. The other one we keep on hearing about the openings. For example, case manager's opening. So, what exactly is the role of the case manager?
Yes.
Could
Yeah,
also
yeah. You are very.
What is the typical staff size of any particular ADR center?
Yeah. Correct. So yeah, I think we missed that discussion during that point which you raised. So you see, arbitration or dispute resolution ADR for that matter, there are basically two types of that.
Yeah.
One is what we call the ad hoc process. Ad hoc means it is totally party driven. The party decides everything right from who would be the arbitrator or mediator, and what would be the process involved, how it's going to run. The whole thing is decided by the parties, and especially the appointments of the arbitrator. That is called ad hoc, and which is very prevalent in our country on a larger level. The second type is what is called as the institutional arbitration or institutional mediation, for that matter, ADR. So what happens here is that a particular institute or an arbitration center, as we call it, they would have their own set of rules to run an arbitration proceedings or a mediation proceedings. And these centers would have these positions known as the case manager. Now, the position of a case manager is very similar to a tribunal secretary in an ad hoc arbitration. So the case manager is somebody who would, as a term suggests, would manage, in the sense it is more of an administrative, position. But it is very, very important from the institutional perspective and from the perspective of a person learning the nuances of the whole process of institutional arbitration. So this case manager would be, doing everything like manage the whole process, keeping track of whether it is going according to the rules as according to the process which is agreed. So you learn everything, every part of the process of what is happening in that particular case before the institution. So this is, I think, is another career prospect which as a student you can look into, to becoming a case manager. Because internationally, it is the institutional ADR which is more prevalent, which is more acceptable, which is the norm, rather than the ad hoc. I'm not saying ad hoc is not there internationally, but if you just try to compare, internationally it is more institutional rather than ad hoc. So yes, it is a very similar position to tribunal secretary, and it also has a huge scope and opportunity as a career.
Okay, nice. Fantastic, sir, for sharing your thoughts and ideas. Now, I would request the students, both our esteemed panelists have shared their magnificent thoughts, very thought-provoking in nature. Now, I would like my students to be prepared with questions which they may have. They can either raise their hand or they can formulate their question and drop that in the chat section. If they have attentively listened to the session, they should be having few questions. The students?
I think I just saw one question popping up some time back.
Yes, Srishti Upadhyay has raised her hand, and you can go ahead, Srishti Upadhyay.
Good evening to both the panelists. I'm Srishti Upadhyay, student of LC2. So my question is, as you said, that earlier the lawyers had only the traditional options like to be a litigator. So I would like to say that nowadays students are choosing other options because of various factors, and one of the factors is financial stability. Because I think, and most of us do think so, that if we want to be litigator and we want to start our own practice, we don't see any money for 5 to 6 years. And if we want to gain that financial stability earlier in our life, we are seeking other options like ADR. So I want your opinion on this. That is there financial stability in ADR?
Yeah, Samir sir, would you, Javed sir, would you like to answer that?
Yeah, I think, see, one of the things that, again, I'm going back to my pet subject, technology, how it is going to impact the legal this thing, because I would suggest that you read this book called Tomorrow's Lawyers by Richard Susskind.
Yeah. He has also written one particular book, End of Lawyers.
Yeah, End of Lawyers. So in that book, he analyzes the whole how the tomorrow's legal paradigm is going to be. Okay, and he points out different new jobs for lawyers, like for example, legal technologist. Then he talks about legal hybrid. Uh, then he talks about legal process analyst. Then he talks about legal project manager. Now, Samir has already told you about the case manager prospects. That is part of ADR, right? And one of the, I think there's a huge scope because now the Mediation Act, once it is notified, it's already been passed by the two houses of Parliament. It has to be notified. It has to be signed. The President has to give the consent. Now, once that comes into existence, there is a provision there for establishment of institutions that are called as mediation service providers. That is where I think students can play the new lawyers, the future lawyers, when you start off your practice. I think you have a lot of scope for being case managers in these institutions. Apart from assisting mediators during mediation, assisting arbitrators during arbitrations, you can learn mediation advocacy and you can assist clients in mediations. You can learn negotiation and assist your clients in negotiating deals. Now, for all this, I would echo what Samir said, because today, see, back in our days, Samir will agree with me when nobody used to give us a house on rent, or those days arranged marriages were in fashion, and no father would agree to give the daughter in marriage to a lawyer, because it used to take 10 years for us to really start making money. Of course, you people are spending a lot of money for the legal education, because back in my days, my father would have probably spent about 30 to 40,000 in a year for the 3 years that I studied law. But today you're spending in lakhs. So obviously you are in a hurry to make money again. But any profession, it's not just the legal profession, I think any profession takes some time. And I think what is more important for you to focus on is to learn as much as you can. And that's what Samir has stated so emphatically, because it's that learning, because you're still young, and you have to learn as much as you can on how the future is going to be and what you need. What are the skill sets that you will be needing in the future? Apart from your knowledge of the law, what else do you need? So these are the skills that I think you need to do as many additional courses as you can on negotiation, on mediation, on arbitration, on digital media, how to handle that. Of course, you people are experts in that. You don't really have to learn it, but still, the nuances of that. All these things, I think you need to equip yourself before you really look forward to start making money. It's easy to join a law firm. What happens in a law firm? You're dumped a whole lot of clerical work that you keep doing. And what is it that you are actually learning in the process? I don't know, because I think learning, somewhere comes to a standstill. And I don't know how the future is going to be if you stop learning. Sorry, my power has gone here.
Yeah. Javed sir, there is one particular question by Priya Goyal, which she has dropped in the chat section. And she's asking, how do you see mediation evolving in response to global challenges such as climate change or healthcare disputes?
See, there is a lot of scope for mediation there because, see, one of my friends, for example, is working as a mediator for the World Bank. And she does a lot of work traveling to different parts of the world where World Bank wants to set up its different projects relating to the environment, relating to development of the areas. On all these, a lot of intervention is required by people who will listen to the stakeholders there. For example, if supposing you want to establish, let's say that you want to develop a particular area for a particular purpose, then there is a lot of resistance from the local populace there because they don't want some company to come there or establish its business there. So this is where mediators are called in to mediate with them to understand what their concerns are, to address those concerns, and to advise the companies that are going to be establishing the business there. So there's a lot of scope there because in all these, especially in competition laws, I see a lot of scope there. I think those skills will be useful for you in almost every field. So even if you're not mediating, even if you're negotiating, understanding these nuances of how you deal with issues, what kind of questions you ask, these are skills that are going to be useful for you in every facet of life, especially in these fields.
Fine, sir. Samir,
let me just add to what Javas had said, and just to answer this particular question in just one sentence. I think the approach and the scope is that anything and everything that can be litigated can definitely be mediated. That's the scope. So you can understand the vast scope of mediation in each and every dispute to start with.
That's a very important point that Samir made. Just to add to what he said now, normally we say that in criminal law we cannot mediate.
Yeah.
Now, I came across a very interesting case from Canada where a hate crime was committed by a teenager and he happened to kill another teenager for reasons of race or whatever. Now, the court ordered mediation between the two mothers and it was mediated. And both the mothers got together and decided that instead of punishing this teenager, they would give a proper upbringing and teach the proper values to this teenager so that he grows up to be a wholesome individual. So there's a huge scope here, not just in commercial disputes, not just in social issues, community disputes, but also in criminal law.
Yes, sir.
I think this book of Pascal would be a very interesting book to read on this. I'm sure, Javasa, you would have read Pascal Commonwealth. He has written a very interesting book on exactly this topic of mediation in criminal disputes. So I think as students, you should read all these kind of and that's what I have mentioned, reading not only your law textbooks, but these kind of books from experts, which will give you that insight into the subject. So continuous reading is very important.
Even I can share my current research, which is about UN in mediation. I'm basically a teacher of international law as well as alternative dispute resolution. So I'm into currently UN role in mediation. So even in the criminal field, mediation, the role of mediation has increased exponentially. The UN is undertaking many reconciliation projects in war-torn countries, and we can critique it, but it is a reality these days that even mediation is being offered, is being utilized for resolving criminal cases, criminal matters. And the idea is that for how long the communities will remain up in arms against each other. When the society has reached this stage of peace, they should forget their past. So we can critique it, but it's a reality that criminal cases are also inviting the use of mediation. One particular question, we are now left with very few minutes, so I can take up two more questions raised by Ritika Agrawal. She's saying, my question is, what are the best internship opportunities available in the field of ADR? Like, should they go for internship opportunities? Are these internship opportunities offered to the law school students who are currently admitted to the law program? Samir sir?
Yeah, of course. Internships are regularly offered both by for law firms in our country and internationally also. So what my advice to the students would be that during their time in the law school, try to combine the experience of both kind of internships, the domestic and international. Keep lookout, and that's where I said social media and especially LinkedIn will immensely help you into that. So be active on that. Network, I think there is no other substitute of networking. You have to do it. Even we ourselves, even now today, after being such established, we are still doing network. What the conferences are for? Of course, they do have discussions, a healthy discussion takes place, but ultimately, every conference has a networking session, and that's what it's all about. So you attend these conferences, go with internships, both into domestic and international part, and gain that experience, because that is what is going to help you. There is no overnight success, let me tell you this. It's a hard reality and you have to accept it. If you are here for making overnight money, it's not for you. Just go out of this. Otherwise you will get frustrated. Accept the reality that you have to give time to reach a particular scale, to reach that. And yes, even today, the good law firms are paying a very good amount to the associate level, who just starts afresh. It is a different, topic of discussion, as Jawad sir pointed out, what actually you would gain from these kind of, internships or these kind of jobs in big law firms. But yes, if you really want, they do pay you well. There's no doubt about that. So you have to decide what actually you want to do. You want to stick to a law firm kind of a career. Yes, another job prospect which just came to mind, which is in-house counsel. All these big companies have their very robust, important legal cell within their companies. So you can, and that's another very important and lucrative career prospect. In-house counsels of companies, as a lawyer, as a legal advisor, as a consultant, you can, and there's a good money in that. So internships definitely plays a very vital role in your career as lawyer. But as I suggested, try to combine these two, domestic and international, to gain much more experience into that. That's what I would say.
Yes. Just 1 minute, I just want to add something, because see, you have to make a choice. Are you happy being a glorified clerk, or do you want to become a professional? Now, if you want to become a professional, you need skills, you need experience. Now, experience takes time. You don't get experience by just reading a book or doing a course. You need to work on it. So if you want to be a professional, you have to be patient. You have to be patient. You have to develop your skills. You have to do a lot of networking. You have to learn a lot of things. You have to do a lot of work. If you want to be a glorified clerk, you can join anywhere and just do the job and get a salary of whatever you earn every month. So it's a choice you have to make.
Samir sir, I have one particular question in relation to the openings available in the law firms. Everybody knows that the governments around the world are encouraging parties to go for mediation. And in that scheme of things, they're also using mediation for resolving public disputes. So I just came across with this idea, like, are there openings so far as mediation experts are concerned also available in the PSUs? Like, do they have mediation cell where they also...
Not yet.
Yeah, but then that's a rising area.
Yeah. I mean, the ultimate responsibility again goes back to lawyers. All these PSUs have do have their own legal cells, and they do have their external legal counsels and advisors. The problem is that neither the people involved in a legal cell and nor the external legal counsels, they don't have that experience or the knowledge about how to best resolve the dispute through mediation and other ADR models, or they don't have that inclination because they are still coming with that traditional thought process of prolonging the dispute and just trying to getting the money out of it. But things are changing and things are going to change and things are changing, especially after this mediation act coming into play in our country. I think there would be a major revolution in the system of dispute resolution in our country. And if PSUs are not following, if they are not ready to follow it up, they will be the loser, not the system or not the people. So it's better that they just accept this and appreciate and follow the system. Otherwise, it is they who will be the losers, not the system or the people.
Fine, sir. Sir, there's a last question, and I hope that this is going to be the last one. Raised by Udita Keshri, a student of law faculty. She is asking about the ODR, the prospects in the arena of ODR, online dispute resolution. And she's particularly asking whether adopting ADR platform will be better option in all types of cases, which can be resolved through ADR. Like the one which is resolved through ADR should be rather first attempted to be resolved through ODR. I think that's the.
Jawad sir definitely is the expert into that, but let me just begin with saying that go back to the COVID time. What happened throughout the world? Why today we are talking of ODR? I think COVID actually had this positive, change to bring ODR into the mainstream. It's not that ODR, for that matter, was not there before. You see, internationally, arbitration proceedings were still conducted even before COVID through video conferencing and even telephone calls. The initial preliminary meetings used to happen that way. It is only COVID which made this drastic change and brought the ODR system, especially Zoom, into the mainstream dispute resolution. And I think that's going to be the future. There's no doubt about that. There's no alternative. It has so many benefits to the parties. It's flexible. I mean, look at the way we are today having this event. I am in US right now. Jawad sir is in Ahmedabad. You people are in Delhi. But we are still connecting. So that's the beauty of ODR. Coming to the ODR platforms, definitely. I mean, I have been using the ODR platforms, both made by our own Indian, people. Many, in fact, students like you, young students like you, and international platform as well. So that's the future, and you must use these technology to for the efficient process of ADR. That's what I would just say. Javed sir, over to you.
Yeah, Samir, I absolutely agree with you because one, ODR platforms are time agnostic and space agnostic. You can sit anywhere. You can be dressed in your pajamas. As long as you wear a jacket on top, it's absolutely fine. You can do the ODR. Okay. So, and when we talk about ODR, it's not just about Zoom, it's not just about Google Meet, it's also about resolving disputes over various other, telephone call is ODR. Negotiating over a telephone is ODR. Right? Exchanging WhatsApp messages is ODR. Exchanging emails is ODR. Right? Now, apart from all this, we have these, wonderful platforms. We have Zoom, we have Google Meet, we have WebEx, various other things. And they work very effective, let me tell you this. Because I do a lot of court-annexed mediations. Courts refer matters to us for mediation and we mediate. Now, I used to travel 25 kilometers every day to the court from my house, go there, and sometimes parties don't turn up, they get held up, and the mediation center will be crowded, and parties won't have place to sit down. Now, all that magically got transformed during COVID. And I used to sit at home and mediate, and even today I do the same thing. And I informed the court that, look, if anybody is willing to do it online, please refer to me. If they want a physical mediation, please refer it to somebody else. And many people choose to do it online. Like I had this mediation, before the COVID happened, where it was a matrimonial dispute between husband and wife. And the lady was not turning up for almost 2 or 3 sessions. She did not turn up at all. And she was not represented by anyone. So I was going to close the mediation, and then COVID happened, and then everybody forgot about it. And then the court reminded me that, look, there is this mediation pending. What do we do about it? So I said, the lady has not come, but here's what we can do. We just send her a notice, and I'll give you the Zoom link, send it to her, and ask her if she can join. And she joined. And I asked her, why did you not come when it was posted for the in-person sessions? And she said, I have a 2-year-old kid, and I don't have anyone to look after the kid. I can't leave the kid alone and come for the mediation, and I can't carry the kid and come over there. So this is very convenient for me. So you see, there's a whole lot of convenience here. But traditional people would tell you that, look, it's important to see the body language. It's important to empathetically connect. Believe me, that empathetic connection happens even online. Right? So we are able to, there are so many people I have made friends with online. Okay, and we do connect online and we become good friends. We conduct these sessions. So the most convenient thing is we are saving, we are contributing a lot to the environment also. Imagine traveling all the way to Delhi. I'm based in Chennai. I have to come all the way to Delhi. And Samir has to come all the way from the US to Delhi to take part in this if it was a physical conference, right? So imagine the amount of pollution that we would be doing, how much of damage to the environment. So from all these perspectives, I think ODR is something that is here to stay. And as Samir rightly pointed out, that was one of the biggest boons that came from a very sad thing like the pandemic.
I think, sir, when you talk of environment, what ODR actually helps you, the best benefit to environment is paper.
Paper.
Today,
Absolutely.
So huge amount of paper is being used in the physical hearings.
Yes.
Whether it's ADR or court. If we move on to these ODR platforms, so imagine the amount of environment benefit it will create. No use of paper at all. Yeah, everything is digital, online, and it can be saved, it can be protected. We have now the new data protection law in our country. So it's safe and sound. So why not use it? And that's the future. Only thing I would say, and as Jawad sir very rightly said, we have to just see how best we utilize this technology. It's not going to substitute humans, that's for sure. But it is for us, because you see, you have to appreciate this fact, this who made this technology? It is us. We have made this technology. That is why it is called artificial intelligence. It's not called human intelligence, because human intelligence cannot be replicated. Yeah, that's why it's called artificial intelligence. But we have to be cautious that how we use it rather than how technology uses us. So that's the caution point.
Wonderful, sir. So it's been an enriching experience listening to the two eminent panelists, experts in the field of ADR. And I hope that this is going to stay with us. The students must have learned, even teachers like me interested in the various nuances of ADR. I feel immensely benefited. I hope the students must have also learned a lot listening to you. And your reflection on the various facets, especially the job prospects available in this field, are going to be very helpful to the students. So let me also make some brief, summarize what the two eminent panelists have shared here in today's enlightening session on the job prospects in ADR field. So I will just briefly summarize so that things become more, objective for the listeners and the participants. Um, Beginning with Javed sir, uh, he enlightened about the role of the mediation in particular. He was more focused on the mediation, and we all know that he's one of the leading mediators in this country these days, and he basically alerted the students about the immense prospects available in this field by giving this data that it would take 350 years approx to clear the pending cases in this country, and that too when no new cases are filed. So, and he also suggested that out of these 350 crore cases, almost 30-40% of the cases are interpersonal conflicts, so which require the students to know the immense potential of mediation and negotiation and arbitration, which is going to be very helpful in resolving this vast, huge areas and of cases pending before the courts across the country. And he in particular shed light on the role of AI, which is, to my mind, is extremely crucial. We cannot escape the reality that AI is going to impact the dispute resolution field. And therefore, he alerted the students and even the law school administrators that beware about and adapt your curriculum in accordance with the growing role of AI in the field of dispute resolution. So that is a takeaway for the teachers like me, and we will be thoughtful about it while we reframe the courses. And he shared about one particular aspect of AI when he talked about IBM developing AI tools which could even read the human emotions like anger, empathy. So that's something which is going to throw a lot of challenges to the traditional lawyers and the traditional dispute resolution experts. And he highlighted the fact that mediation has a human touch, and in order to be successful in the arena of mediation, the students must be taught and the students must be exposed to the nuances, art and science of negotiation skills, problem solving skills, etc. So that's something which is very important. Students must remain watchful about what he said, about the skill set which is really required to be a successful mediator. And lastly, he did talk about the importance of negotiation training. And on this, we hope that some of the students must be willing to have extra skill set in the negotiation, because we at the law school only exposes the students to the basic skill set in the art and science of negotiation, so they can be thoughtful of joining negotiation training. And he again lastly alerted the immense scope of mediation because of the preemptive role of mediation in diffusing, resolving the conflicts around the world. So these were the essential takeaways coming as it did from eminent expert on mediation, Mr. Javed sir. The second panelist, Samir sir, has really thrown a lot of enlightenment so far as the dispute resolution methods are concerned. He is more into arbitration, which is the field yet occupying the alternative dispute resolution method. Arbitration may face challenge from mediation, but it is not going to happen anytime soon. And arbitration is a huge field which students must remain watchful of in so far as searching job and career is concerned. And he really gave very beautiful, enlightening, practical inputs to the students when he talked about various types of openings available in the law firm as well as in the ADR center, and he very critically diagnosed the elements required to be a case manager as well as tribunal secretary. So, which is something very new for me also. I was not knowing. Some of the students can even think of writing blog on what these positions require, what is the role of the case manager, what is the role of the tribunal secretary, and he really shed light on the importance of reading, researching, and mooting. These are the three skill sets which are really required to excel in this field. We cannot, even in the wake of AI proliferation, we cannot undermine the importance of reading. Even I tell my students, keep on reading every day. At least few pages every day you must read. So reading, researching, and mooting, these are the three skills required to excel in this field. He also talked about being honest while you do networking, and he highlighted the importance of the LinkedIn in this regard when he said that LinkedIn has emerged as a very good platform for students, for professionals alike, so far as creating networks online is concerned. And over such social media platforms, he alerted that we need to be quite honest and we should not be boastful about what we don't have. So he talked about the ethicality of networking in that sense. He 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 also talked about the importance of drafting DR clause, dispute resolution clause, in contract, which is something very much required for students willing to work in the field of ADR. So DR clause constitute the most important aspect as highlighted by him. And while drafting the contract, every care must be taken by the drafter and to make sure the DR clause really reflects the needs of the parties. And and he also, which became, I was also very much impressed when he said, which I also keep on saying to the students, do not ignore jurisprudence. Jurisprudence is the heart and soul of understanding law. So I'm really glad that he said that and highlighted the importance of jurisprudence in understanding and building a career in law. Of course, as in dispute resolution domain as well. So with this thoughts shared by the two eminent panelists, I think all of us have gained a lot, and we are really feeling quite enriched so far as the theme of the session is concerned. So while I formally thank the two eminent panelists, I now hand over the podium to Priya Goyal, online podium to Priya Goyal, who will take charge of the session now.
Thank you, sir.
So just adding here, since I am really focused on student development, so you are free to share my emails to them.
Yeah.
And all of them can connect with me on LinkedIn. I'll do my best to help and guide them, whatever questions they have, if they're facing any issues, they want any clarification, doubts, anything, just connect with me and I'll happy to help you out.
So could you share your LinkedIn ID, sir? Or we can...
It's, I can do that on the chat.
You can write that in the chat section, sir. You can drop.
Dr. Ashish, the same from here.
Yes.
My name is Jawad AJ on LinkedIn. So Jawad AJ, I think that.
Jawad
AJ.
AJ.
So you can, same, just search with the name. And LinkedIn, it's just the name and you can, it will pop up.
We will find it and we will share it.
Yeah.
Thank you, sir, for sharing.
And I would really just add one last thing. Keep a good connect with Jawad sir I mean, if you really want to understand mediation, he is the best person to do that in our country. So don't leave him. Just follow him on LinkedIn and just go on pestering him. And I'm sure he's so patient to help you out.
Thank you.
Thank you, sir. Thank you so much. With this, we have come to the end of this really insightful and illuminating session. I would like to extend our heartfelt thank you to the distinguished speakers who graced us with their knowledge, insights, and inspiration today. Your wisdom and expertise have enlightened our minds and broadened our horizons. I would further like to thank our teachers, Dr. Ashutosh Mishra and Dr. Rohit Munka, for always supporting and guiding us. Lastly, I would like to thank the audience. I hope you all gained valuable knowledge throughout the series. Let us stay connected through the social media to make the most of our upcoming events. Thank you.
Thank you, sir, for giving this opportunity and this nostalgic part of coming back to my alma mater. Maybe I mean online as of now, but I would definitely be visiting when I'm back in India. It's been long time to come back to CLC.
Thank you,
Sure.
Dr.
This-
Ashish, for the excellent moderation.
Thank you, sir.
Thank you. Thank you to all
I
of
think
you.
we can fix another session maybe 6 months from now regarding different facets of ADR. Like ODR in itself has emerged as a great platform, and the students, even teachers, don't know much about the various technical requirements of conducting successful ODR session and what are the critical legal questions and justice issues emerging in that context. So we can think about that, and also the importance of drafting DR clause. That's something we may be thoughtful of conducting separate session because
I
we
think,
have.
sir,
Yeah.
sorry to interrupt you. My suggestion would be that when you're taking up the ADR, I mean arbitration, conciliation, mediation as the subject,
Yes, sir.
maybe after maybe after a month or two, if you have these kind of expert talks on whatever has been covered,
Yes,
that
sir.
would help student to understand the practicality aspect also, and to broaden up their knowledge. So after each session, if you have one such small expert talk on what have been covered till that session, I think that is what I have been seeing. It's not happening in our law school system. You do have these kind of lectures and guest lectures and experts coming to play, but there has to be a system, there has to be a process, therefore, so that it remains a continuity. You are doing the expert lecture after the whole act has been done, it's not going to help the students.
Rightly
So
pointed
if
out.
after each of these session you have a half an hour, 1 hour of such kind of expert lecture to refresh the whole thing what they have been taught in that lecture.
Fantastic idea, sir. We will really implement what you have suggested, and I hope that maybe within 1 month or 1.5 months we shall meet again because this field has grown rapidly, and we really want students to be well versed with different smaller facets of the dispute resolution methods. Okay, sir. We will be mindful of that. Thank you for.
Thank you so much.
Thank you, panelists. We will meet soon. Thank you all.
Hello.